Good morning, everyone. I want to welcome you to our telecommunications workshop this morning. I appreciate your attendance and participation this morning. We are going to use the agenda that's been posted on our docket management system under docket number 2020-247A. And we will begin with the South Carolina Telephone Coalition, followed by the Office of Regulatory Staff, then the South Carolina Cable Television Association, and finally the Department of Consumer Affairs. So, Ms. Fox? Ms. Fox and Mr. Bowen, good morning.
Good morning.
Good morning.
And you have someone else with you, don't you?
No, we do not.
You don't? Okay, all right,
Yeah, just Mr. Bowen and me this morning.
all right.
Thank you, Jocelyn. Good morning. Good morning, everyone. John and I are here representing the South Carolina Telephone Coalition, and we filed some comments in this docket regarding Article 6 telecommunications regulations. Just as an overall just overview, I think it's important to note that telephone utilities operate in an industry that's becoming more and more competitive every day. Voice services increasingly are not the landline telephone service that most of us grew up with. The telephone networks themselves are still critically important to all of the ways that we communicate today, but increasingly that's things like wireless, voice over IP provided by cable and other providers. When we were reviewing the telecommunications regulations, we were doing that with the thought process that to try to streamline those and make them more fair, because with telephone utilities operating in a competitive environment, we do understand the need for some regulation, but it is not the same as other regulated industries like electric, where you've got assigned service territories. So it is a situation where you have to find that balance so that the regulations you place on telephone utilities are not onerous, because that would put them at a disadvantage vis-a-vis their competitors for voice services. So with that, and an eye toward looking at reducing regulation where it makes sense to do so, we reviewed the regulations, and I'll just summarize very quickly, or fairly as quickly as I can, the comments that we filed. I would note up front, I think there is universal agreement on the comments that we filed. I did not see any comments filed that disagreed with any of the points that we made. So except for with respect to one minor thing that where we and ORS disagree a little bit, that I'll mention in the comments. So the first thing that we had was in regulations 103-618 and -619, service quality and held applications reporting. We believe that annual reporting is sufficient. This is the one area that where ORS did disagree and felt like that the quarterly service reports should be continued, and they say they use those. Our feeling on that is deal with the problems and not have just a quarterly reporting for quarterly reporting's sake. And I think ORS had a suggestion on interruptions of service, where when there was an interruption of service that lasted more than 24 hours and impacted, where you've got service impacting issues, we think it's better dealt with on a case-by-case basis in that manner, as opposed to with quarterly reports. But I do understand where they're coming from on that. Regulation 103-628C, complaints. We thought it would be helpful to clarify that was complaints for regulated service. And I know ORS receives a bunch of complaints, well, not a bunch, but some complaints for non-regulated type services provided by telephone utilities. And they frequently have to tell consumers, well, that's not something that we can deal with because it's not regulated service. So we think it would be helpful to clarify that in the regulation for consumers who are consulting the regs. Directories. This is a big issue for our companies because for a couple of reasons. One is the obligation to publish and distribute automatically to all customers printed directories is number one, it's an obligation that's been placed only on incumbent local exchange carriers, so which is even a smaller subset than telephone utilities, which is a subset of everyone that provides voice service. So you have a small segment of carriers who are required to do this. And the commission routinely has granted waivers of this requirement to other competitive local exchange carriers. So that's one thing, but more importantly, people just don't use printed directories anymore, and they're just becoming obsolete. So wireless phone numbers are not printed in directories, and that's a large chunk of residential telephone numbers. That's an example. Directory assistance, Google, people using cell phones and having numbers stored in them. There are all kinds of alternative ways to obtain information about telephone numbers, and the directory, the printed telephone directory. I mean, I don't recall the last time I even saw one, but if you're automatically distributing them to everyone, they're ending up in the landfills, and so that's an obsolete requirement that we think can definitely be streamlined. A couple of other minor things. So regulation 103-652 regarding testing, it said as requested by ORS, we said as reasonably requested. Haven't had a problem with that, but that's something that we think should be in there. The reg 103-663.2, the failure rate standard, that should be clarified with less than symbols. That's just a typo probably. The regulations 103-680 through 684 dealing with the Telecommunications Relay Service Advisory Committee are based on a statute that's been repealed. We think those are obsolete. And then probably where the most controversy is on the streamlining the regulations for ETCs under regulation 103-690 and 103-690.1. 690 being the initial designation of an ETC, and 690.1 is the annual reporting of ETCs. We propose to streamline those to make them more consistent with the FCC regulations while retaining some of the South Carolina public interest specific requirements that allow ORS and the PSC to monitor ETCs and ensure that they're meeting the obligations that they should be meeting. As I said, I think everyone agreed with our comments. The Cable Association goes a little farther, and we do not agree with going farther than what we've proposed. The ORS did have one minor tweak that they dealt with respect to the annual reporting in their reply comments, and we do agree with that minor edit that ORS proposed. But with that, I believe everyone's in agreement with, at least as a baseline, our redlining of the ETC regulations. But again, we don't agree with doing away with outage reporting and unfulfilled request reporting, or doing away with the service improvement plan. Generally, that requirement has been waived where there is a specific federal program like RDOF or CAF2 that has more granular reporting requirements, and we think that waiver process worked well. And but there may be future ETC applicants that aren't required to granularly report under a federal program, and so the service improvement plan requirement should stay in place, and it can be waived when it is appropriate. Generally, we're in agreement with ORS's comments as well, other than that, minor skirmish over quarterly versus annual service quality reporting. We agree with those portions of the Cable Association's comments that are already incorporated in, I think, 80 or 90% of what we're saying is the same, and so we would argue that our edits to the ETC regulations capture everything that should be captured. The Department of Consumer Affairs comments, I think, fairly minor comments on interest rates. Again, overall, we just believe that the regulations there shouldn't be additional regulation on telephone utilities, but we should look to streamline these regulations where it makes sense to do so. And so, you know, we would disagree that that's necessary. We've not had an issue. I think those regulations are very, very rarely, if ever, invoked. I can't remember the last time there was a, you know, for example, for willful overcharges, that would essentially require a finding by the commission of willful overcharging. So that I'm not aware of that having happened in recent memory. And so I think those changes are just not necessary. I think that's all we have, unless Jocelyn, you have some questions of us.
Yeah, just some clarifying questions, okay, for me.
Sure.
Okay, so Peg, and I hope it's okay if I call you Peg and John this morning.
Yes.
Okay, as it relates to ORS, the only you're of a different opinion as it relates solely to the frequency of the reports and 103, 618, and 619. You agree with ORS's recommendation from May 19th regarding its ETCs, and that the information be submitted at they strike the words wire center level and just say the level of designation. Everything else you agree with ORS, right?
Yes.
Okay. All right. So what was I going to ask you? Then you mentioned, Peg, that the Telephone Coalition, South Carolina Telephone Coalition, believes that the annual reporting requirement is sufficient and that the reports should be dealt with on a case-by-case basis. So if the reports are annual, Peg and John, are you recommending reports be filed after an incident happens? When you said on a case-by-case basis, I was just wondering the timing of, should something happen that ORS needs to be notified of prior to the annual reporting deadline?
Yeah, I think what I was referring to there, Jocelyn, is ORS in their initial comments suggested an addition to the interruption of service reg 103-614.
Thank you. I don't know why I said ETC. It was... Okay, go ahead. I'll interrupt it. I didn't mean to say ETC. We're talking about 618 and 619.
Right. So from our perspective, quarterly service reports, you know, everyone I've seen is just, you know, there's no problem every quarter. And so our thought was that could be done on an annual basis. And we think that there are other regs like this interruption of service reg, where if there truly is an issue, that separate reporting is required. And ORS's comments of May 11th, they are recommending an additional sentence in that interruption of service regulation that would require reporting directly to them if there is a service affecting issue. And so we think that sort of reporting takes care of when you're having the problems, so you don't necessarily have to do the quarterly service reports, and you'll still be getting the information. You'll just be getting it on an annual basis as opposed to a quarterly basis, so it reduces a little bit of the reporting burden. But when there truly is a service affecting issue, ORS will be getting that reported in real time.
Okay, so I understand now, because ORS on May 19th on page 2, they do reference the 103, 618 and 103, 619, and their preference to retain the current requirements. And what you're saying is not, when I asked about the case by case, what you're basically stating, Peg, is that you feel other regulations would sufficiently cover any service reports that are necessary prior to your proposed annual reporting frequency.
That's right.
All right. Ms. Miller?
Yes, ma'am. Can you hear me?
Yes, ma'am. Would you please mute your microphone, please. And then when you need to speak, you can let us know. We're hearing some feedback, please.
I will do that.
Okay, thank you so much, Peg, for that. Then moving on to directories. So I remember when this discussion was uh, during the last time the commission reviewed all of its regulations over a decade ago. And I remember the discussion then. I think there was a proposal, I think I'm recalling correctly, to modify paper directories. And so I wanted to ask you something. For those individuals who still need some assistance, still need, maybe they're using perhaps the traditional means of finding numbers, and they're not relying on their cell phones or other electronic devices. Do you have any type of campaigns that are in place right now that assist those customers with um, being aware about your services, the numbers they can call? Like everybody knows, I think, in this day and age, what 911 is, and what the purpose of 911. Or do you think customers are just as knowledgeable about other ways to locate numbers? And I mean customers of all ages who should be using the telephone.
Well, Jocelyn, I would say I'm not aware of any campaigns. I think, obviously 911 it makes some of that regulation obsolete because we are required to put police, fire, ambulance numbers in the front of a directory, which is everybody's aware of 911. And by the same token, I think it's pretty universally known that 411 is a directory assistance number that can be called. But as far as any specific campaigns, I'm not aware of any. And the reason is because our folks currently are required to publish and printed directories and distribute them to every customer. So that is that's the requirement today, and so that's what they do.
Mm-hmm. Okay, well that's when I say campaigns. Perhaps that was not the right word. Um, I'm just looking for, should the commissioners decide to delete the need or get rid of the need for telephone utilities to publish directories, will customers who still rely on them, what type of transition can be made so that they fully understand that there are other ways to find those numbers that they were looking
Yes.
for?
Yeah, I think, that there was an order several years back where this dealing with CenturyLink, moving away from the automatic requirement to print and distribute directories, and our folks would probably, I almost certainly follow a similar path where they would make sure their customers, because again, they're in a competitive industry, they don't want to make their customers upset, they want to do what their customers want, and so what they would likely do would be to notify all their customers that they're going to stop automatically distributing the directories, that they'd be available upon request, and that will save the environment and everything else, kind of like everybody going to paperless billing. And so the customers would still, for some period of time, have printed directories available upon request until such time as there's just so little demand for it that it doesn't make sense to print them.
Yeah, I appreciate you bringing that up. You didn't have to. The CenturyLink docket sounds like there was a phase out of them, of the directories.
Right.
I'll
right.
look that up, and I think we need to look into that. What happened in that docket, and perhaps propose some of that. I don't think Department of Consumer Affairs or the Office of Regulatory Staff opposes this recommendation. So I'll find out shortly. So maybe a phase out and a plan. And I could be worried about nothing, but a phase out so that customers are aware and they have time to adjust.
Yeah, I think our folks envisioned that anyway, and I think they'd be fine with that, Jocelyn.
Alex and Connor, I'm gonna come back. Don't forget, I need to ask you about those directories. Make sure I didn't misspeak, okay? All right, moving on, Peg and John, 652 on testing. Really quickly. The word reasonability, I was wondering if we needed to, or reasonable, is reasonably requested by ORS. Did you have in mind any other descriptive words that could be used, or what the standard of reasonably means?
I think just what is reasonable given the circumstances. That, and as I said, we have had no issues with ORS on this, but it's just a concern for what might come in the future if you say you have to do whatever tests ORS requests. There just needs to be a reasonability standard there, that if it has to be a reasonable request, they can't say, come and say, hey, you have to do these $1 million worth of tests, and no, we're not having any issues, but we just want you to do them. And I mean, it's just what is reasonable given the circumstances. I think that would be implied anyway, but I think it's helpful to say.
So some of the concerns would be that the requests aren't, that they're fiscally, I don't want to use the word reasonable again, but they're not too costly. I wrote that down, Peg. I was just looking, perhaps that we could, the staff could just, the standards I think sometimes aren't efficient if they are too broad, and it places an onus on the company, the commission, and the other parties, because some examples haven't been given. And when I say efficient, I mean making sure we're using everybody's time, we're respecting everybody's time. So I don't want to be too wordy, but any examples I think that we can give as to the justification or the thinking at the time that the regulation is amended, I think is helpful. So I've written that it's not too costly. Is overburdensome? Is that what you and John had in mind, kind of? Peg?
Yeah, I'm thinking, Jocelyn.
Oh, okay.
Yeah, I think so. I think it's it's hard to say because it really is going to be given the circumstances at the time. So, for example, if they're having a service issue that affects one customer, is it reasonable for them to require tons and tons and tons of testing? So that's a cost thing, I guess. And I think you're going down the right path, Jocelyn. It is a concern over cost and burden.
Okay, I appreciate that. I think we all want to use our time wisely, so, and then 10 years from now, when everybody's looking at this regulation again, what did we mean? And I think there's nothing wrong with what's proposed. We'll forget about this conversation later on. Yes, sir.
Yeah, I think that along the lines of what Peg's saying, right now there is no standard at all. Okay, we assume a reasonable standard, but there is no standard. So I think our concern was that, hey, if there's no standard at all, then anything could be requested with respect to testing. So therefore, if we just put the word reasonably in there, then at least it gives the companies an opportunity, if they feel like that what's being requested of them, and we've never had an unreasonable request, but if an unreasonable request, we feel like an unreasonable request comes in, that we then can say, hey, we don't think this is reasonable, and then the commission can arbitrate whether or not it's reasonable or not reasonable. Right now, the way the red reads, It seems to us is potentially the ORS could come in, which they have not done. ORS could come in and say, hey, we want you to do this testing, and we don't have any options. So that's our concern.
I understand. But you're not, are you okay with those two descriptions I just gave about the cost and burden, John and Peg, as examples?
I think those are examples, but I think once you start setting out examples, you get away from the whole concept that it's going to be so situation specific that you can't anticipate what would be reasonable or unreasonable given the circumstances that exist at that time. I mean, do you agree with that?
I totally agree. I think the word reasonable is a better thing to put into the reg rather than, I think the examples you give are good examples to give to the commissioners as they're trying to decide whether or not to use the word reasonable. That the examples you give are reasons why, but I think the reasonable is a better middle of the road word to use under the circumstances.
Okay. All right, let me see if I have anything else. That's all I have. Thank you.
Thank you, Jocelyn.
Thanks.
Alex Knowles? Mr. Knowles, are you?
Good morning, Jocelyn.
Good morning. How are you?
Doing well. How are you?
I'm fine. Are you
So
ready to present your summary?
Yes, ma'am. I'll just go ahead and jump right on in. Just starting with ORS's initial comments and working on down the list. So ORS recommends updating Regulation 103.612.2.4 on authorized utility representative information, simply to conform to the form that the Commission is currently using. ORS recommends that Regulation 103-614 on interruption of service be amended to require additional reporting for major equipment or infrastructure outages lasting more than 24 hours. This additional reporting guidance will assist ORS in receiving timely information on service interruptions in order to better work with affected utilities. Like the Telephone Coalition, ORS recommends that Regulations 103.680 through 103.684 be repealed because former Code Section 58.9.2540, which has regulations implemented, has been repealed. And also, like the Cable Television Association, ORS recommends updating the Commission's regulations to remove references to link-up service. And like both the Telephone Coalition and the Cable Television Association, ORS does not oppose repealing regulations 103.690.c sub a sub 5 and 103.690.1 sub b sub 8. Turning to ORS's reply comments, ORS does not oppose the Telephone Coalition's proposed changes to Regulation 103.690 and 103.690.1. As you were discussing with Ms. Fox, ORS agrees with what Peg was saying, and based on ORS's review of the Telephone Coalition's proposed changes to these regs, ORS agrees that they could help to streamline the existing regulations while retaining important protections. ORS recommends amending the second sentence of 103.690.1 sub b sub 1 to provide that progress reporting information shall be submitted at the level of designation. ORS does not oppose the Telephone Coalition's recommendation to amend Regulation 103-628.c regarding customer complaints, but ORS does just want to ensure that the proposed change from the Telephone Coalition wouldn't, impact ORS's ability to refer customers who have complaints about unregulated service to the appropriate point of contact. and ORS doesn't read the Telephone Coalition's proposed amendment to bar ORS from doing that, but we did, out of an abundance of caution, just want to raise the issue for clarification. And let's see, as discussed previously, ORS does not agree with the Telephone Coalition's recommendations to amend the reporting requirements of regulations 103, 618, and 619 to provide for annual rather than quarterly reporting. ORS believes that quarterly reporting better allows ORS to detect quality of service degradation and to work with the company to resolve any issues before there is a more significant impact on quality of service. ORS did oppose the Cable Television Association's recommendations regarding Regulation 103.690.c, sub A, sub 1, sub B, and the filing of service improvement plans. The FCC has not waived all service reporting, and ORS doesn't recommend removing all service reporting requirements from the Commission's regulations. ORS prefers the approach as outlined by the Telephone Coalition to amend 103.690. Let's see, ORS also opposes the Cable Television Association's recommendations regarding Regulation 103-690.c sub B at this time. If the Cable Television Association does have specific proposed amendments for this regulation, ORS recommends that they provide a red line so we can review those changes. And ORS also opposes the Cable Television Association's recommendations regarding Regulation 103-690.1.b, sub B, sub 1, sub 2, and sub 3. For sub 1, just as ORS opposes eliminating the service and progress reporting requirements at the time of designation, ORS opposes eliminating updates to initial reporting. For sub 2, ORS opposes eliminating the CTC outage reporting requirement. ORS disagrees that it's merely duplicative of other reporting requirements. And for sub 3, ORS opposes eliminating unfulfilled service request reporting. You can see the common theme here as ORS wants to be cautious about reducing reporting requirements and just wants to ensure that all necessary information is available to ORS. As you were discussing with Peg, Jocelyn, yes, ORS does not oppose the Telephone Coalition's recommendations relating to printed directories, and ORS also has no problem, no opposition with adding inserting the word reasonable into Regulation 103.652. Happy to discuss any questions.
Okay, thank you for going ahead and answering those regarding those two issues, the directory, elimination of the directories. And that the ORS does not oppose using the word reasonably. Alex, I may ask on your comments dated May 19th, the change in 103.690 and 690.1, the additional amendment that you recommend regarding deleting the wire center, is that the current requirement under the federal regulations? I think I recall some of that language. I recall some, I think, waivers for some of the applications that were recently filed with the commission under the this federal rural digital opportunity fund. I just recall even though the commission's, I think it was a waiver of granting ETC status. And I remember the wire center being referenced in those regulations, but I was wondering just where the reason for deleting the wire center level from ORS?
Yes, ma'am. And it wouldn't necessarily, my understanding is eliminate receiving information at the wire center level. It would just tie the reporting to the level of ETC designation.
Oh. Just in case the ETC is not providing services for an entire wire center, is that the?
Yeah,
that what you mean?
For instance, like with RDOF, where you know, the ETC designation is at the census block level. It would just
Okay. That's what I was looking for.
create
Thank you.
create the reporting there.
I don't think I have anything else. Give me 1 second, please. No, I don't. Great job. Thank you.
Thank you, Jocelyn.
We're going to move on now to the South Carolina Cable Television Association. Mr. Willoughby, do you want to identify yourself, your colleague, and your witness, presenter?
Absolutely, Jocelyn. Thank you very much first of all, for allowing us to appear with you here today in the hearing room. That was very much appreciated. The introductions today are with me is Ray Sharp, who is the Executive Director of the South Carolina Cable Television Association. And a few years ago, Mr. Sharp actually had the opportunity of working with the Public Service Commission. So he is he's glad to be back among very good friends. Appearing as counsel today is myself, Mitchell Willoughby. And in the presentation box is Andrew D'Antoni, a lawyer with our firm, Willoughby and Hafer, here in South Carolina. And Andrew will be making the comments and the presentation on behalf of the Cable Television Association.
Okay, thank you very much. Ms. Purvis and Ms. Thomas, should I minimize this so that we can, or would you like to would like for Mr. D'Antoni to introduce himself first before we, okay. I think it's on. I think the microphone's on.
Sure, yeah. Hi, good morning, everyone. Andrew D'Antoni, as Mitch Willoughby said. I work with Mitch at the law firm Willoughby and Hafer. We're here on behalf of the South Carolina Cable Television Association. We're here with Mr. Ray Sharp. It's an executive director. And we do have some slides. Okay, wonderful. Yep. Okay, too easy. Thank you, Jocelyn. Okay, our comments are going to focus primarily or really exclusively on eligible telecommunications carrier designation and annual reporting requirements. As we note in our comments, our state's ETC designation requirements, they largely tracked the federal ETC designation requirements at the time of their promulgation in about 2008. Technologies and circumstances, however, have changed over the intervening 13 years, and FCC ETC regulations have been subsequently revised to match these new realities. Our comments are meant to align state ETC regulations more closely with current FCC regulations, technologies, and circumstances applicable to eligible telecommunications carriers. In this way, we hope our proposed revisions will improve and not hinder what is an increasingly competitive environment for telecommunications services. And what we'll do is we'll just walk through each of our proposed revisions that we made in our comments. First things first, as far as link-up service, and I believe that this is agreed to with the Telephone Coalition as well as ORS, The FCC eliminated link-up service on non-tribal areas. So again, we agree with ORS and the Telephone Coalition that the reference to link-up service be removed from the body of state telecommunication regulations. Next, we also recommended that the 2-year service plan be removed. The FCC has waived a similar service improvement plan, both for Connect America Fund Phase 2 and Rural Digital Opportunity Fund participants. The FCC stated that the purpose of its related 5-year plan and annual updates was to ensure that ETCs use their support in a manner consistent with achieving the universal availability of voice and broadband. However, ETCs are now subject to a detailed broadband build-out obligations, which the FCC found provides a more defined yardstick by which to measure their progress toward the universal availability of voice and broadband services in their areas. We note that the Telephone Coalition also proposed eliminating from the body of state regulations the 2-year service improvement plan, but also it appears that they also proposed eliminating ETC designation requirements from 103.690.c.82 through 7. And it appears what they did is to tie the state's ETC designation requirements to the FCC ETC designation regulations at 47.54.201 and 202. The association concurs with these proposed revisions that bring our state ETC regulations back in line with current FCC requirements. And to the extent ORS likewise concurs with these revisions, we concur with ORS. Next, the association recommends removal of the equal access certification requirement. That's found at 103.690.ca5, and then the related annual reporting requirement at 690.1.b8. Equal access is no longer a requirement under the FCC's universal service rules, and I believe that the Telephone Coalition likewise proposed removal of this requirement as well. Moving on, the association also proposes revising Rule 103.690.c.b, and this is the public interest requirement. Now, the way you can go to the next slide here, and this is our strike through and underline on how we propose to revise the public interest standard. And the current public interest standard largely tracks former 47 CFR 54.202, the first sentence, the second sentence, and the third sentence. The FCC, however, has subsequently revised this regulation. They simplified the regulation and the public interest requirement. And what the current regulation reads is just that first sentence. The FCC struck the second and third sentence. And we propose, again, with our general theme of bringing state ETC regulations into harmony with FCC ETC regulations, we propose the same strike through of our current public interest standard. The last sentence is a little bit different. This is dealing with the Commission's designation of ETC service areas. And the way it currently reads is that the Commission shall not designate a service area to an ETC that is smaller than an entire wire center. And as Jocelyn mentioned, there have been several waivers or many waivers from RDOF applicants seeking to waive that requirement because the FCC targets RDOF funding at the census block level. And what we tried to do with our proposed revisions is to create an enduring regulation that also conforms with the existing FCC regulation insofar as service areas. And what it's meant to do is to tie the ETC service area to the geographical area that the recipient is receiving universal service support. So the way it would read is the Commission shall designate a service area to an ECC consistent with the geographical areas for which the carrier shall receive support from the Federal Universal Service Support Mechanism. And that's whether that's at a wire center level, census block, or partial census block level, or otherwise. And we saw in the reply comments that ORS had some concerns with a partial census block designation. We would point out that in the RDOF order, there are, in certain circumstances, times where RDOF funds are directed at the partial census block level. Because of that, we propose the revisions here on this slide, again, that we believe will bring or will create an enduring requirement for an ETC designated service area without the need for waivers in the event that the direction or the geographical area in which universal support funding is directed changes at some point in the future. Next, we also proposed eliminating the annual outage reporting requirement at Rule 103.690.1b, B2. The FCC eliminated this requirement for eligible telecommunication carriers because this data is collected from all facilities-based providers in the network outage reporting system. And it's our understanding that the FCC has recently adopted rules to permit state agencies to apply for access to NORS, which is the network outage reporting system. So consistent with our overall emphasis in realigning our state rules with existing FCC rules, we propose eliminating this requirement. We also note that this takes advantage of existing system efficiencies, such as the NORS system, to reduce the administrative burden on carriers. Next, we proposed eliminating the unfulfilled service request reporting requirement, and that's at 103.690.1.b, B3. We note that the FCC has also eliminated this requirement. The purpose of the requirement was originally to track deployment of supported services. However, the FCC has ways in which they can monitor that deployment. For instance, the high-cost universal broadband portal is a portal and system in which carriers participating in programs like CAF Phase 2 or RDOF have to file broadband deployment data within the hub, showing where they are building out high-speed internet service using federal support. This information includes latitude and longitude coordinates for every location where service is available. So again, taking advantage of existing technologies, existing systems that are out there to reduce duplicate efforts on the part of carriers meeting both state and federal ETC requirements. The last is the Lifeline annual verification. We note that the Telephone Coalition likewise eliminated this requirement and tied it to current FCC regulations. We would concur with that, and we also, with the Lifeline annual verification reporting requirement in particular, we note that with the national verifier, the individual reporting is no longer necessary. And again, we're taking advantage of existing systems to reduce duplicate reporting burdens on carriers. And pending your questions, Ms. Boyd, that's all I have.
Mr. D'Antoni, I really don't have any questions. I'm a little concerned with Mr. Knowles's need to receive the reports. You might recall him saying that,
Sure.
that they just want to be cautious about reducing reporting requirements, and I should have asked him this question too. Under any of the other, let me get your comments, under 690.1, capital B, little lowercase b, 2 and 3, all the FCC's reporting requirements have been eliminated, basically, for ETCs to file, or are you filing? There we go. Are you stating basically that ETCs are no longer required to make any reporting requirements, file any reports under, let me find it again. The service improvement plan.
So there is a 5-year service improvement plan under federal regulations.
Oh, right.
And we do concur with the South Carolina Telephone Coalition that eliminates the ETC designation requirements under our body of regulation and instead ties that to, for instance, 47 CFR 54202, which sets out federal FCC ETC requirements.
Okay. And ours currently require an annual filing.
Say again.
Under 690.1, yes, it's an annual requirement, an annual progress report.
Yes, so
Yeah.
that would be the related annual progress report that's tied
To the 5
to the report to the current 2-year service improvement report. Again, to the extent we are tying our requirements to the FCC ETC regulations, we would support that.
Okay, I think what I'll do is go back to Alex
Sure.
and ask him. Because I think his point was that ORS would still like to have those reports
Mm-hmm.
on an annual basis. I think I'm recalling his position correctly.
Yes, I believe they had some concerns with the unfulfilled reporting requests that go annually.
Uh-huh.
As we mentioned, we believe for the same reasons that the FCC believes that's no longer necessary. That reporting was initially meant as a tool to help the FCC track build out.
Yeah.
Since that time, the FCC now has systems in place. We gave an example like the Hub portal to precisely monitor the build out of carriers.
Do you know if they're tracking their electronic tracking system, if any of those reports are available publicly?
As we understand it, the state commissions can gain access to the Hub. Let me look into that a little more, but that's our understanding.
Okay, I was just looking. I understand ORS's position too, so I was just looking to see
Sure.
if that information can still be provided to them, but just some other way.
Mhm.
If they're already tracking it, I don't know the details, but it appears as if the ETC is having to file it with them. Maybe.
The idea is just to reduce redundant efforts. So
Right.
if there's a system out there and the FCC has aggregated this data under the system,
Right.
it just seems prudent and efficient for us that the parties consult the system as opposed to having a separate reporting requirement in addition to what you're reporting to populate the database.
Okay. And I think we as staff too, we can kind of check and see what might be available
Sure.
and still meet ORS's concerns. So, all right, let me see if I have anything else.
High level, but very strong.
Hey, Jocelyn,
Yes, ma'am. Yes, ma'am.
may I just say something? I know, we've got a formal agenda, but it is still a workshop and it's fairly informal.
Mm-hmm.
If I could just, I think there's a little confusion there. Again, everybody is in agreement with the coalition's streamlining of the ETC regulations, but that doesn't mean that they should 100% conform to the FCC. We think where it makes sense for them to conform, they should conform. But I wanted to point out that Congress said that it was up to the states to designate ETCs in their own states and to ensure that that is in the public interest. And so some of the requirements, I want to say we concur with ORS and their comments because we think that some of those requirements that are in there, while they may not be exactly the same as what the FCC would require, they are things that ORS feels are important in order to ensure that when the PSC is designating ETCs, that they are doing it in a manner that is consistent with the public interest for South Carolina. So I just wanted to make sure maybe that clears up a little bit what the difference is between the coalition proposal and the cable proposal, because I think 90% of what we're saying is the same, but that is the one area where we differ and where we concur with ORS.
Okay, thank you. Mr. D'Antoni, I don't have any other questions right now.
Sure.
Okay. Thank you, and thank you for the slide deck.
Yes, ma'am. Thank you.
Appreciate it.
Thank you for the opportunity to speak.
Yes. And the Department of Consumer Affairs?
Yes, ma'am. Good morning.
Good morning, Mr. Parker. How are you doing?
I'm doing well. How are you?
I'm doing fine, thank you.
So the Department of Consumer Affairs submitted a couple of comments under its authority as the state consumer protection agency. The DCA regulates and enforces the Consumer Protection Code, which often involves consumer credit and interest issues, or finance charges, as it's called in the Consumer Protection Code. And so in reviewing these regulations, we came across the willful overcharge section in 103-623. And it caught our attention because it discussed interest. And we could not locate any order or other prescription of the interest rate that would apply in a willful overcharge situation. And so we wanted to comment on that to bring that to the commission's attention in the event they wish to clarify what interest rate applied or whether it should be decided on a case-by-case basis. And then the other comment that we had comes from the department's role in receiving and mediating consumer complaints. We receive thousands of complaints annually, oftentimes from businesses who owe a consumer a refund. And we've seen oftentimes where the business is slow to issue that refund. And so in reviewing 103-623.2, we saw perhaps an opportunity to extend the consumer protections further under that regulation to require the telephone utilities to refund overcharges within a specified time frame. And then we've also, added in there the possibility of an interest requirement there if an overcharge is not refunded within a specified time frame. We understand these comments are general in nature, and they are filed in our capacity as the state's consumer protection agency. So if you have any questions for us, we'll be glad to answer that. I know you mentioned earlier the directories. What would our position be on the directories? We support the recommendation to remove that requirement. The proposed amendment had directories or electronic database. That seems to be in line with the earlier comments about the usefulness of printed directories in today's world. That an electronic database may be more useful and less burdensome on the utility. But Ms. Boyd, you did bring up a concern that if there are consumers out there that do continue to use a printed directory, what could be done about that? And I suggest perhaps still making it available to consumers that are holding out on the digital age, I guess, that still rely on printed directories. Perhaps they can request one from their provider. And that concludes my comments.
Okay, thank you. I want to ask you one question about the interest in just one second. I want to write your notes about basically a printed directory being available upon request.
Rather than mandatory, perhaps it could be something that the consumer could request.
Thank you. And then I don't know that that other one, 103-652, really pertains of impacts rather the Department of Consumer Affairs. It's related to the South Carolina Telephone Coalition's use of the word reasonably, as reasonably requested by the ORS. And so I mentioned your name early, but I don't know that you really have an opinion or want to care to share one on that, since I think it impacts ORS. So, back to just one point on your comments, please, dated May 11th, related to the interest prescribed by the commission.
Yes, ma'am.
And the department's recommendation that the interest rate be tied to some other source, to a reliable, reputable source. Did you have any in mind? For example, maybe the U.S. Treasury bond rate? Did your department have any thoughts in mind as to what you might want that to be tied to?
We could provide some analysis on that. I do know there is a money and interest statute that sets a legal rate of interest that, absent some order or writing, could arguably be the applicable interest rate. And I don't know the code section off the top of my head for that statute, but I can email it to you if you'd like.
Excuse me. If you find it, I can look for it too. The money interest statute. That's
I may be able to find it as we're on the call now.
okay. That's a good idea. I like that idea. I was trying to think if whether or not the department had a source in mind that they'd like for us to review and include. We could not find any. We could find a couple on the 12% for electric utility rate cases in the commission orders, but we couldn't find a complaint where the commission had to order the amount of interest due to a willful overcharge. And so I think it would be helpful
Yeah,
to.
the South Carolina code section on the legal rate of interest is 34-31-20. And it is set at 8 3/4%, which I would call that 8.75.
Thank you very much.
Thank you.
That's all I have. So thank you, Mr. Parker. Peg and Mr. D'Antoni and Alex. I want to make sure that I'm recalling before we leave. This will be a quick question. I think Peg and Alex, basically what you're saying is the reporting requirements that that exist in the commission's regulations are not exactly the same as the current FCC reporting requirements. And I don't mean the frequency, I mean the substance, the content. And Peg, I understand what you're saying about the FCC, or Congress rather, through its regulations, providing the commission's authority to designate and imposing requirements on ETCs. But I want to make sure that I understand also that some of the commission's requirements, reporting requirements, differ from the FCC's requirements, reporting requirements.
Right.
Okay.
So I think what we've left in there is things like reporting service outages, reporting the number of unfulfilled requests, can't designate at an area smaller than a wire center unless you receive a waiver, and we understand that. Things like that the Cable Association is arguing for, that go beyond what we streamlined, all deal with the public interest, and that's in the purview of the commission to determine whether or not it's in the public interest to designate an ETC in the first place. And and I think the commission and I believe ORS believes that if an ETC is not going to report those kind of things or make those kinds of commitments, then it wouldn't be in the public interest to designate them as an ETC in the first place. So that's why some of those are retained where they're not in the FCC regs, because it's not up to the FCC to designate an ETC in South Carolina and determine whether or not that's in the public interest for South Carolina.
All right, Mr. D'Antoni, did you want to go around? Did you have any other comments? And just, oh, yeah, okay, yeah.
I can speak right here.
All right.
Yeah, we acknowledge that there is a state role in the ETC designation process. But we find that the reasoning underlying many of the FCC revisions are sound and should be applicable to ETCs in South Carolina. We believe that taking advantage of existing databases and aggregations of information by the FCC and thereby reducing parallel state reporting requirements for ETCs in this state is an efficient utilization of resources. So that's, again, we concur with the FCC's underlying reasoning. We understand that the state has a role in ETC designation, but the FCC's, we believe their reasoning is sound and the systems that they have that should be taken advantage of.
Thank you, Mr. D'Antoni. Peg, thank you so much. And Alex, did you need to add anything? Any comments?
Just real briefly, Jocelyn.
Okay.
As far as, we don't disagree with taking advantage of, existing avenues for accessing information made available by the FCC. We do have concerns that the hub may not provide all of the information that we need, and ORS specifically does believe that unfulfilled service request reporting provides important additional information. So that's all that I wanted to add. Thank you.
Thank you. Well, everyone, I really appreciate, I think this has probably been our shortest workshop, but thank you for your participation this morning. The South Carolina Telephone Coalition, the Office of Regulatory Staff, the South Carolina Cable Television Association, and the Department of Consumer Affairs, and maybe we will see you next Friday, hopefully. If not, if I don't see you next Friday, I hope that you, well, even if I do, I hope you have a great weekend and you remain safe. Thank you.
Thank you, Jocelyn.
Thank you.
Appreciate the opportunity.
Yes.